And for those of you who are joining part 2, welcome. This part of the series is titled, So Your Client's Buying a Business, Drafting the Purchase Agreement and Ancillary Documents. So welcome to all of you in Toronto, as well as those of you in London, Ottawa, Thunder Bay, and Waterloo. Just a couple of quick announcements. I know you've heard this before, but please remember, if you have a cell phone, to turn it off. Please remember to complete the evaluation form. It's at the front of your materials. And for those of you on ILN, you can fax it back to us. For those here, there'll be a drop box on the registration table on your way out. In Toronto, we do videotape so that we can distribute in video format, so your voice or image may be captured on videotape in Toronto. Also, if you're in one of our ILN locations, please remember to fill in the sign-in sheet. And a quick comment on the Q&A. Rob will be taking questions in Toronto impromptu, but we will have a designated question and answer period for the ILN locations at the end of the program. So for those of you in our ILN locations, if there are no questions, please indicate no questions so that Mr. Hyndman knows to go on to the next site. I just wanted to mention that on the outside table, there's specialist certification applications and materials if you want to pick that up for the new corporate commercial law specialist certification. Also, we're starting something new. We've provided a bowl with a sign that says, if you'd like to be a speaker at a Law Society program, please drop in your card. So please let us know if you have any interest in speaking, and we'll be following up with you. Finally, I wish to again thank Rob Hyndman, who's the chair of our Business Bootcamp series and today's sole presenter, for the enormous amount of work and time he has dedicated to both planning the overall series and preparing today's materials. Rob practices in the area of corporate and commercial law at Ogilvy Renault, and I refer you to his biography in the materials, and now turn it over to Rob. Thanks.
Thank you. It's the first time I've tried one of these lapel mics, so I want to make sure that it works. Can everybody hear me? Is it okay? All right. So in your materials, you have the presentation that I'm about to give today, although I've revised it a little bit. And at the end of the presentation, you'll see my email address if you want a copy of the updated presentation. It has, I think, 5 or 10 more slides in it. Just email me, and I'll make sure that you get a copy of it. So before we start, I wanted to thank Stephanie and the staff at the Law Society. And actually, a lot more work than you would think goes into organizing these programs, and it's a terrific resource. So all of the effort is very much appreciated. We are, in the fall, going to continue the program, and the intention now is to run a program called the Case Files series, to be a little bit different from what we've done so far with the boot camp. The idea will be to run sessions that are perhaps a little bit smaller than the ordinary large lecture format, break off into small working groups, tackle particular problems in the respective area of study. So we might have, for example, an hour and a half or 2 hours broken out into 2 or 3 different problems, where the group will split up into 2 or 3 different groups, analyze problems, come back into the larger format, debate, discuss, negotiate. So far, we're very sort of flexible on what we're planning, but that, broadly speaking, is the intention. And I think it's a novel presentation outside of law school. So my impression so far, based on what we've got going, the plans we've got, and the people that we've got lined up for it, is that it could really be a very interesting thing to attend. Today's presentation is going to be, I think, more practically oriented than you might see in the typical lecture format. That is the underlying concept for the sort of boot camp approach that we're taking. So there is an extensive series of precedents in the materials you've got, but in the presentation and also in the paper, we've interspersed a lot of more practical, technical tips, observations from experience. Not the kind of thing that you typically see, again, in the large lecture format. Now, the presentation overlaps with the paper, but it's not 100%. So there are some differences between the two. And as I said, I have revised the presentation, but please feel free to contact me and I'll make sure that you get a copy of the revised presentation. So, before I really get into it, I wanted to just spend a couple of minutes talking about purchase and sale of a business essentially as a practice area. Some people spend a little bit of time doing this. Some people spend a lot of time doing it. Some of you might never have done a deal like this and may have the opportunity to do it on occasion in the future. In some respects, this practice area actually can be, with apologies to anybody here who genuinely is fabulous, actually fabulous. First of all, there's an enormous amount of variety in the practice area. Purchase and sale of a business involves buying and selling a wide variety of different types of businesses. So for people who are interested in knowing how things work and getting into the nuts and bolts of the way things are done in business, it's a terrific area of practice. You have to ask the kinds of questions, you have to ask questions that really drive at the way things work and the way business conducts itself. Very often in corporate and commercial law, you don't have the opportunity to do that. We look at the world almost through sort of a theoretical lens, the world as an abstract. This is actually very different. It's about the way things work, and you really do get the opportunity to talk to operating people about the problems and issues that they're faced with on a day-to-day basis. I think it's probably also fair to say that you work with a really wide variety of people who are really smart. Most of the time, M&A is handled at a relatively senior level in businesses. So you might have an EVP or a VP running the M&A project, and various people within the organization are reporting to that person along functional lines. These people very often are terrific. They really know what they're doing, and they, through the process, can actually teach you a lot about how their businesses operate. Another thing that I love about this is that you do have the opportunity to actually get into a significant amount of technical complexity. There are areas of law where that is generally not the case, and there are areas of law certainly that are more technically complex than this, but to my mind, it's a really comfortable place to be if you like working with large technical contracts and working on relatively sophisticated legal concepts. And the last point is, at least from a legal standpoint, you're quote-unquote running the deal. The business person will very often really look to you for advice. Very often they've never done this before. We tend to think of business people as people who come to us with problems that they've dealt with before and who just need somebody to help them with this instance. In the M&A world, that may be the case. You have clients out there that are highly acquisitive or that have, for example, gone through a process of selling off businesses. But you very often work with people who've never done it before. They lean on you, and that can give you an enormous amount of influence over how the process actually unfolds. But it also isn't fabulous a lot of the time, and here are some of the reasons why it might not be. There tends to be an enormous amount of stuff going on all at the same time. And you have to be comfortable with managing multiple tasks that are different types of tasks and keeping all of it going at the same time. Some people find that very frustrating. They like to have one thing that they're paying attention to at that particular time. This is one of the things that really drives some people crazy about M&A. And of course, when clients come to you, it's with hair on fire, pants on fire. Everything has to happen right away. Nobody has, to my knowledge, has ever said, we want to buy or sell this business, and we're just going to do it, in the fullness of time. Once people have made this decision, there's often an enormous amount of time pressure behind the project. It might be because, for example, the deal needs to get done before the financial reporting period comes up, because people want to book the deal on a particular quarter. It might be, and I see this happening a lot. It might be because the particular business prime has this particular deal booked into their bonus structure for that particular pay period, that year, whatever. One of their objectives is get this deal done by the end of the year. For whatever reason, it tends, when it comes, to be very aggressively timed. And unfortunately, a lot of the stuff that you could have contributed to help work the process along has already happened in the background, and people are kind of coming to you a few weeks, maybe even months after they really ought to have, and they're saying, okay, we've got, I don't know, a signed letter of intent. Now all we need is the contract and we can close the business, close the sale. M&A can involve a lot of due diligence. Due diligence can be real drudgery. On the bright side, one of the ways the world works in this area anyway is that after a little while you move beyond responsibility for due diligence and you naturally take up responsibility for other things. And due diligence is an important place to learn how to do things, but it can be extraordinarily dull. After a while, things start to look the same. There is technical complexity and there's a lot of variety, but there's only so much. And I'm telling you, after the 500th, and I'm exaggerating there, non-disclosure agreement or letter of intent, you start getting a little fuzzy-headed. You also sometimes have experiences with clients who really aren't as good as what they're supposed to be doing as you are at what you do, and that can be frustrating. Clients, as I said, very often have never done this before, and we also often assume that clients know what they're doing. Well, very often they just don't. And dealing with a client like that can be very frustrating. All of this, of course, is just the way life works, and I'm sure the same can be said for any number of other areas of practice. So next, let's spend a few minutes just talking about the M&A process, the process of purchasing and selling. Right at the outset, you should appreciate that it's absolutely vital that you have a pretty solid understanding of the business that's being bought and sold. That understanding feeds into the entire M&A process. And you really do a better job if you can answer the question, what really am I buying and what really am I selling? That's for a variety of reasons. You need to understand how, for example, as the purchaser, you're going to protect yourself. What are the real risks that you're buying? Why are you buying this business? Where does the value come from? What are the threats to you capturing that value? What are the potential liabilities in the business that you need to protect yourself against? You also need to, I think, to some extent have an understanding of this, because at the end of the day, if somebody litigates your agreement, somebody may sit in judgment of it and ask, all right, well, what did they mean by this? And they'll find that one phrase that nobody really paid a lot of attention to, and that maybe you just wrote down because your client dictated it to you. And maybe you said, all right, does that have a common usage in your business? Because you didn't know. And they said, yeah, sure. And you went on faith. And that turns out to be the thing that everything turns on, and you didn't really pay enough attention when you wrote it. So having an understanding of the way things work in a particular business helps you to draft the document, gives the document more life. I tend to focus, for example, on information technology businesses that use intellectual property. And I spend a lot of time reading about it just because it's kind of a hobby of mine. And I'm absolutely convinced that one-on-one against a lawyer who doesn't work in this area, I have an advantage. I have disadvantages in other areas. One of the ways that you bring yourself up to speed is to find out what publications your clients are reading. What do they read? What are the trade rags? Get them, read them. Another very important part of this process is what happens right at the beginning. before you're really talking about the purchase agreement, before it's even a glimmer in anybody's eye. I really believe that one of the key ingredients to success in negotiating in just about anything, and certainly in this area, is creating an expectation in the other side's mind about what your side wants and what it stands for. You're essentially branding your client with almost everything you do. You want the other side, when it's asking itself, how will they react to this? What will they think of this? To have a clear picture of what you want and why you want it. Now, you start down that road very early in the process. You need to have the right meetings with your client, obviously, but you need to put yourself in the right mindset so that at every opportunity to interact with the other side, you're creating the right expectations and you're laying essentially the foundation for the negotiating strategy that you're going to pursue. A vital part of this is the way you present your position, and there are certainly a wide variety of negotiating styles out there, but my personal view has always been that the most effective negotiating style is to take the moral high ground and to present yourself consistently with a sensible position that is defensible with regard to objective standards that everybody can agree on. You can never waver from that. You may, at the end of the day, agree that you will not insist on this, that, or the other thing, but there are going to be sensible, defensible reasons for doing that that don't betray the overall strategy. The best negotiators I've ever seen always do that. They're relentless. They're like a dog with a bone. They know what they want, and if they get pushback, the reason for why they want it is always the same. As I've always said, bang, 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 over and over and over again. Sooner or later, that wears the other side down. You also, to some extent, can guilt people into agreeing with you because they can see that your position has, an internal logical integrity, has been presented with goodwill, and if you're up against people who are flopping around all over the place, they're coming at you with this position, just to try to drill through you, sooner or later, and I've seen this over and over again, people will yield. I feel very strongly about the moral high ground. We obviously all are aware of the rules of professional responsibility, but time and time again, I've gotten things out of people just because I try to present myself as somebody who's likable enough that they don't feel badly about giving things to me. You create credibility, you create trust. When you create that trust, you create goodwill. This all allows people to believe you. When you say something to them, they will believe you. And you can't expect people to sort of go along with you down the road that you've chosen if they don't buy into what you're saying. You will have many opportunities in this area of practice to be rude if you want to be. And you see it all the time. One of the things that drives people absolutely nuts dealing with long documents, 60, 70 pages long, is style comments. There are lots of different styles out there for these types of agreements. Everybody has their favorite. My view has always been that you need to really resist the instinct to style something the way you're accustomed to it. This is two sides coming to the deal. M&A is no different from any other area of practice in that regard. We're under a lot of time pressure often. As I've said, you frustrate people and you slow the whole process down when you give people comments that aren't really presented the way you'd like them made. Can't tell you how many times I've seen things like question marks in the margin. Everybody here's probably been through that. What the heck do you do with that? Well, you get on the phone and you call somebody, and then you leave a message, and they call you back, and they leave a message, and et cetera, et cetera, et cetera. Things don't get done. So my approach, wherever possible, is to prepare typed riders that have exactly what I want, show exactly where they're wanted, and then I email everything over. Something ideally that the lawyer on the other side can just hand to an assistant. Obviously, you need to be timely, and you need to be, when I say that, you really need to be responsive to the schedule that's been laid down for the deal. My experience has almost always been that being difficult and trying to score points off of other people just inevitably comes back around on you. Everybody here's probably seen this, but we all know lawyers who, for whatever reason, feel it's important to demonstrate the vast breadth of their knowledge and the depth of their experience by scoring cheap little points off other people. And that is what it is. It never helps to get things done. And M&A is about getting things done. And the last point is something that I find helps you to remember sort of everything that's come before. This is not about us. And if you do it really well, you're almost invisible to the process. It's about the business people. I have to try and remember that. So, process. There are broadly speaking, two different types of purchase and sale agreements. First is the sign and close. The second is the sign and then close, which is also called an executory agreement because there are principal covenants that have yet to be performed on execution. You might agree with somebody that you're going to buy the business at the end of the month, and the agreement that you're working on between now and then says, we agree that today I'm selling you this business, and everything speaks as of that day. On the other hand, there may be circumstances, and they tend to come up where there are key third-party dependencies like a landlord, a regulator, a creditor, or tasks like an environmental due diligence, a phase 1 or a phase 2 due diligence that need to be done before the closing can happen. People want to execute the document, but they won't be ready to actually close the deal and to do the conveyances until these things happen. When you're in that type of a situation, you're dealing with an executory agreement. Almost the overarching issue when you're dealing with an executory agreement is that you really need to think carefully about the scope of the exits. In an executory agreement, you get to the closing date, parties say, am I obliged to close? The agreement will say that on the closing date, subject to the conditions precedent, you have to close. So what are the conditions precedent? And one of the main issues that you need to think about, and we'll get into this in more detail later, is exactly what is the scope for, on the closing date, the parties to walk from the deal. They're very simple revisions to convert one form of agreement into the other. The document that you've got in the back of the paper is an executory agreement because it's easier to start there. Executory agreements have interim covenants, covenants that govern the conduct of the parties between the signing date and the closing date. We'll get into them later. They have closing conditions. There's a variety of additional covenants in the document. And there are these closing conditions. What you tend to do is just drop them into a closing checklist that guides the administrative work that you're doing to prepare for the signing of a sign and close document. So, I don't know why I started with letters of intent. I should have actually started with confidentiality agreements because sometimes confidentiality agreements are signed before the LOI is negotiated because there's going to be a lot of disclosure during the LOI negotiation process, but we'll get to that in a moment. So, main issue to think about in an LOI, something that business people never think about, ever, and they will often come to you with signed LOIs, I haven't given an ounce of thought to this, is do you want it to be binding or not? There are different terms used to describe these documents: letter of intent, heads of agreement, memorandum of understanding. There's no real magic to any differences here. Heads of agreement, memorandum of understanding tend to be used a little bit more in English in England and Australia and New Zealand. Americans use LOI. But the basic question is, what is supposed to be binding here? Parties will come to this and they will be full of steam, writing like crazy. They've all seen LOIs before. They know exactly what needs to be in it. And they may come to you saying, look, we want to sign this afternoon. Can you bless it? And they haven't given a single thought to the fact that the thing purports to oblige them to do a whole bunch of things that on the closing date they may well not want to do. The process, the letter of intent, is actually very useful for answering this question. Sometimes that's what parties are really doing when they're having these conversations. They don't know yet what it will be like to negotiate with the other side. They're exploring. On occasion, it's not like that. There's an actual formal auction that's been set up, and you got to go through a bunch of hoops before you can even get to the deal. And the LOI is actually a binding offer that must be presented in order to earn the right to do the agreement. But often the LOI is kind of like a mating dance, and it's parties getting to know each other. It helps business people to identify the issues in a very quick, easy, summary fashion. Because they tend to be quickly written, be short, it's almost always the very strong preference of the lawyer involved that they not be binding. Something that you should keep in mind in the context of LOIs and the environment that they create once they've been executed is that at present in common law Canada, there is no duty to negotiate in good faith. So absent an LOI, for example, you can act as capriciously and as arbitrarily as you want. You can act purely out of self-interest. Now, there may be gray areas where parties have existing trust or equitable relationships where this is not true, but generally this is the case. Once you get into an LOI, if you haven't been careful with the way you've drafted it, you could very well find yourself in a position where you have an obligation to act in good faith. Maybe not reasonably, but certainly in good faith. And your opportunity to act with caprice or arbitrariness has been taken away from you. And you need actually to have reasons for certain things, and you can be sued for it. So this is something to keep in mind in the drafting of LOIs. So a common approach is to make certain provisions non-binding and other provisions binding. And where you take that approach, the provisions that tend to be non-binding are the ones that have the real meat. The structure of the deal, the price that you're paying, the payment terms. A party may say, yes, we have financing available. Other deal terms, such as reps, warranties, covenants, and closing conditions. LOIs often have language saying the definitive purchase agreement will contain customary, bing, 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 and the range of ancillary agreements that are going to be entered into. Because at this point, the parties often don't have a lot of visibility as to where the deal is going to end up, and they're kind of roughing their way through. But there are certain things that it sometimes makes good sense to have binding. Obviously, confidentiality, certainly publicity, particularly if one of the parties is a public company and has disclosure obligations. The right of a party to have access to information in order to conduct its due diligence. Sometimes the vendor's obligation to conduct the business in a particular way, for example, in the ordinary course, pending the actual execution of a definitive agreement. Non-solicitation of employees, so the purchaser would agree because it's getting an inside look and might actually be having a lot of interviews with employees of the target, that it's not going to solicit any of them. A no-shop, also called an exclusivity clause, where the vendor agrees that it's not going to, at the same time, be doing this with somebody else. Purchaser wants to know that it's not just being set up as a stalking horse and that it's spending a lot of money on this process for a reason. An agreement by the parties that they will each pay their own expenses, and then a timetable for the deal. So the whole thing falls apart, subject to obligations of confidentiality and non-solicitation, if we haven't entered into a definitive agreement by such and such date. You should keep in mind that when you, if you do an LOI, you later on execute a purchase agreement, there may be some overlap there. So one of the tips just to keep in mind when you're drafting your purchase agreement is, what does it say about the enforceability of the LOI? Are there provisions in the LOI that aren't actually covered in the purchase agreement that you want to have continue? One of the things that people tend to do is the LOI or a confidentiality agreement is exhaustive of all the parties' confidentiality obligations, and so the purchase agreement will have a covenant saying the parties acknowledge and agree to the confidentiality provisions set forth in the NDA, whatever. So here are some examples. In an executory purchase agreement, you tend to have really extensive no-shop and interim conduct of business language. Tends to overlap or even be a lot broader and more powerful than the language in an LOI. Something that people who are starting out in this practice area often don't appreciate is the enormous influence that the LOI has on the give and take, the sort of bump and grind of negotiation of the purchase agreement. You will retire early and wealthy if you get a nickel for every time somebody says, as we agreed in the LOI. And you will talk yourself till you're blue in the face, reminding people that it was non-binding, and you went through this over and over and over again. Business people just have a different understanding of what it means really to agree. There was a moral commitment they each made at the time to embark upon this journey. They've spent a lot of money getting here. It causes an enormous amount of agitation to surprise somebody with a fundamental change, even if the LOI says all over the place that it's not binding. Now, it can be a very effective negotiating technique to leave the really ugly thing that you want to do to the very last minute. And I recognize that. You want the other side to be seduced as far down the road as possible, to have all of its costs sunk, to be emotionally bought into the deal before you nail them with this one thing. You know, we want, for example, to do a 20% holdback because we're really anxious about potential liability and bling, bling, bling. But you need to appreciate that this can really damage the process. And I've been in a few negotiations where people actually springing up on their feet, leaning over the table, pointing their fingers at people in the chest, and generally getting very ugly. And then things breaking off and not coming back either ever or for a long period of time. So something to keep in mind and something to remind your clients. So there's the holdback example. And this is a little bit like playing chicken. It really is. You will sometimes, by the way, be asked by clients to pretend in the negotiation as though this late surprise was your idea to get them off the hook. You need to think about your professional responsibility obligations when you're asked to lie, basically. And I've seen people do this, and I was asked as a first-year lawyer, you can't do that. So some people need to have this explained to them. There could be legitimate reasons for springing surprises on people. Well, we just realized that this was an issue. Well, we didn't get a chance to do all of our due diligence at the outset because you wouldn't give us time to do it or whatever. And there are a couple of precedents at Exhibit A of the paper. So confidentiality agreements, why are they necessary? Typically because at common law, there's an enormous amount of uncertainty about how actually the law protects confidential information. It's one of these concepts that has never really squarely fit into the evolution of the early law merchant. It was kind of scrabbled together with a variety of legal theories, and a lot of us heard of Lac Minerals and Corona, the famous case of the Supreme Court really struggled with this. So we just deal with it in contract. And why do we do this at the outset? As I alluded to earlier, the M&A process, there's an enormous amount of information that's disclosed. And we talked about this briefly. So there are drafting tips, and there are precedents in there, but you need to make sure that you don't trip up on some of the earlier precedents had very formalistic and mechanical definitions of information, documents and things and papers. Of course, we've gone well beyond that now, so don't trip up over that one. Something else to think about, you're generally not just keeping the information that you're receiving about the business confidential, but details about the negotiations as well. This can often be vital for a vendor who wants to strictly control the ability of the purchaser to, on its own, go and talk to customers, employees, regulators, and other people who might have an interest in the transaction. When the purchaser does its due diligence, for example, it creates reports, and those reports contain confidential information. So how do you deal with work product, as it's called? Who gets it? Well, first of all, you need to make sure that the confidentiality agreement picks up work product and applies to it. What is not confidential information? These are the main categories of things that are excluded, but often the difficult question is the one that the agreement never addresses. How do you prove that something is not confidential information? So, for example, how do you prove that it was in the possession of the purchaser prior to disclosure? And some people try ostensibly artful ways of boxing you in. They might say, well, it only falls into category B there if you can present actual business records demonstrating that it was in your possession. This is a really dangerous area because it's information. A lot of it's intangible. It can be exceedingly difficult to know all of the different contexts in which confidential information was received, the different types of information that are out there. As lawyers, we're kind of stuck with this one because there frankly aren't that many cases that interpret these things, and it's often very difficult to know, even for your client, what information is actually in the possession of them and how it got there. In my experience, most of the negotiations I've had in these points tend to come down to who has more power in the negotiations rather than sort of practical questions of what works in the situation and what doesn't. The agreement should specifically state that the only permitted use of the information is to evaluate or consummate the transaction. There is generic language that permits disclosure if it's required by law, by court order, by legal process, et cetera, but there typically is some plumbing in there to ensure that if the purchaser, for example, is required to disclose under a court order, it has to give the vendor notice so the vendor has a reasonable opportunity, for example, by going to court and seeking another order, to limit the extent of the disclosure. And these agreements typically also say that the disclosing party, in our case the vendor, can on demand have returned to it hard copies and can cause the destruction of all information that's in electronic form. And typically this is how work product is handled, and information that's destroyed tends to be certified as being destroyed. So you get a certificate of an officer of the destroying party certifying that the information's been destroyed. What good does that do you? Well, possibly none, but there's not a lot else you can do. What you've got is a documentary record that allows you to at least present evidence and make your case if you suspect later on that information has been retained. One of the biggest deals of the year involved a problem on this point. And the lawyers who drafted the NDA on the purchaser's side didn't know that their document management systems had backups that did not allow selective destruction of electronic information. So they had a choice to make. Do we wipe out our whole backup to comply with this, or do we try and talk our way out of it? And at the very moment that they needed to talk their way out of it, the other side was really, really angry at them for a variety of reasons. So it turned out to be very difficult. You will see this in almost no NDAs, but it's a little drafting tip to keep in mind. If your firm has a document management system that involves periodic backups on a scheduled rotation, you may not actually be able to promise your client that you can delete all information at their request without deleting a lot of other stuff that you don't want to delete. These agreements tend to have equitable relief provisions that are there to tell the judge in whose sole discretion these powers can be exercised, not to exercise his or her discretion. I have no idea how effective they are, but they're in almost all of the agreements I've seen. I read a case last week where a judge said, oh, and by the way, they have this equitable relief language, so that's interesting, but didn't otherwise comment on it. I really don't know how powerful they are. Typically, they also say that there's no warranty on the information, confidential information that is provided. Typically, they also specify that the obligation has a shelf life, and that may be in perpetuity. Some people don't pay attention to this. The practical issue is, for how long will disclosure of the information be damaging? And again, think about the link to the purchase agreement. In a situation where the deal raises merger concerns, a lot of what happens in between sign and close, it can be very tricky. But the sharing of information is something that can certainly be tricky. And the only advice I can give you is consult a competition lawyer earlier. There are procedures for essentially insulating decision makers in the company from information that might, for example, taint them in the eyes of competition regulators. And there are precedents for confidentiality agreements at Exhibit B. So, one of the key deliverables in most M&A deals is the covenant of the vendor or principles of the vendor to not compete against the purchaser once the business has been purchased. These tend to be accompanied by non-solicitation covenants, and the solicitation applies to current and former customers and also employees, and some people don't pick up outside contractors, but in the information technology area, that's particularly important. And so you probably remember from law school, these are some of the key questions. Where may I not compete? For how long? And what am I prevented from doing? Non-competition agreements, including the ones, or the one, I can't remember that I've given you, yeah, the one, tend to have an enormously long laundry list of the things that you're not permitted to do. First of all, they typically say, well, you can't compete, but they say you can't do it directly or indirectly, in this way and that way and the other way and all of these additional ways. Interestingly enough, most of them say you can't compete. They don't say what that means. Some say you can't carry on a business similar to the target business. Some of them say you can't be engaged in any business that has as its business objectives interests that are adverse to the interests of the business that's being bought. Most of them just say you can't compete. I have yet to see any case law on what works best, but I suspect that if you say you can't compete, you're going to be reasonably close to what you want, and if there are particular markets that you want to make sure somebody stays out of, get them down there. The law, as I'm sure you all know, is that these covenants are in restraint of trade. They're void, prima facie void, unless reasonable as between the parties and in the public interest. This, case after case after case, says it's a completely fact-dependent analysis. But in general, in a purchase and sale of a business context, as far as duration is concerned, 3 to 4, even 5 years is actually pretty common. The geographical scope really needs to be tied to the actual geography of the affected business. This can be actually very difficult to figure out when you're dealing with online businesses. And I have no advice for you there because the concept is so new. Just because you've got an internet business that you're selling doesn't mean that you can get the vendor to agree to never compete anywhere in the world. I can't imagine that a court would ever come to that conclusion. One thing that you sometimes see is so-called funnel or blue pencil type covenants in non-competition agreements. They're the kind of thing that appears to be an attempt by the too clever lawyer to get around the judge. They'll say, for a period of 5 years, you can't compete in the subject business in the world or North America and Europe or North America or Canada or Ontario or Toronto, whichever is enforceable. We're starting to see some case law now out of Quebec, and I'm not sure, I think maybe also BC, that indicates considerable judicial hostility to that type of approach. The case that I know of in Quebec was I think it was in an employment context, but I can't see why the analysis would be any different. So here is a common formulation of the main covenant. This is what I meant by the laundry list. The square bracketed number is really kind of a practical issue. At what level could you, as a practical matter, have influence? That tends to be around 5 or 10%. Smart to link to the sale transaction in the recitals. You don't want any argument with the judge over exactly what was being purchased in the purchase and sale. One of the things you're buying is this covenant. The non-competition agreement should say that. Some people actually put the non-competition covenant in the purchase agreement. Seen that done a few times by very well-regarded firms. These same firms will tell you in their legal opinion that they can't give you an opinion on the severability clause and that they can't give you an opinion on the non-competition covenant. So I don't understand why, when you put them together, they seem to be comfortable with a non-competition covenant in a purchase agreement. It seems to me that prima facie there's some enforceability risk there. I've never seen a case. I think it's worth thinking about. You sometimes see an express allocation of purchase price for the non-competition covenant. That may help in enforceability. There are certainly tax issues. There's a recent amendment to the Income Tax Act. I don't think it's enforceable yet, but has to do with the income inclusion in the vendor's hands of that money. That might not be a desirable result for the vendor. Get tax advice. I indicated earlier the equitable the equitable discretion language in the NDA. You see these in non-competition agreements as well. This language is typically in there, and the idea is to give the judge a reason to say, yes, one of the key tests of an injunction has been met, but again, I suspect that judges will make up their own minds. And one situation that you sometimes run into is a vendor is actually going to continue on in the business after the fact and indeed is going to be an employee, maybe even a key employee. So what you often have is overlapping non-competition covenants. You've got one from the person as vendor, and you've also got one from the person as employee. If they're a senior employee in the business, then generally speaking, the law, common law, and the law of equity will prevent them from competing during the currency of their employment and possibly afterwards. But mostly these employment agreements are there to nail that down and to say, for some period of time after the termination of your employment, you will not solicit our employees and you will not compete against us. An employment lawyer will tell you that in an employment context, the enforceability of a non-competition covenant, even from a vendor, is very, very different than it is in the purchase and sale context. Courts hate non-competition covenants from employees. Typically, the most you can get is a non-solicitation covenant, and if there's a very good reason why this person in particular needs to be prevented from competing with you, then maybe. So something to keep in mind is that depending upon how long the person is an employee, you may end up with having no non-competition covenant from them at all. It's a good reason to try to get as much as you can out of the covenant in the non-competition in respect of the sale. I've already alluded to this point. here are some things that vendors try to do. They very often have a specific idea of what they're going to be doing next. Typically, it's related. It's in a very similar area. Maybe they were in a business-to-business market on an online business, and they're going business to consumer. Maybe they were in one vertical and they're going to another vertical. They want to make sure that they're going to be able to do that. They're going to be looking for carve-outs. They also will try to place boundaries on what it means to compete, as I suggested earlier. Can be very tricky if the vendor is exiting only part of a business activity. And this is one reason why it really helps to understand the business, because you're going to be drafting on business terms. You're going to be using terms of trade and terms of common usage in the business to describe the area that's protected and to distinguish it from the area that's not. That's very, very hard to do. And there's a precedent at Exhibit C. Other ancillary agreements that you sometimes see, transition agreements. It may take some time to transition the business from the vendor to the purchaser because there are complicated information management systems that are maybe provided by an affiliate of the vendor and that have to be essentially untangled from the business and new arrangements put in place. Escrow agreements, and we'll get into this idea a little bit after the break, is if some purchase price is held back, sometimes the vendor will insist that it be held in the hands of an escrow agent. I didn't provide the precedent because I typically use ones that the escrow agents themselves like to use, like Bank of New York and CIBC Mellon Trust. They typically cost you about $5,000 to $10,000 a year, and they are liable for absolutely nothing. Manufacturing and supply agreements. This is actually very common in the pharmaceutical business. Company A sells the factory to Company B because Company B specializes in manufacturing. Company A wants to get out of manufacturing. Company A still intends to distribute, so it locks up the buyer in a long-term manufacturing and supply relationship. Technology licenses. Sometimes the vendor may be keeping key technology because it wants to deploy it in some other respect, but the purchaser needs it perhaps just for a period of time. So there's a license of that core technology for that period of time. And as we've alluded to already, employment agreements. How are we on pizza? Is now a good time? Now's a good time. So we'll take 10 or 15 minutes. It's now 5:30. Why don't we try to be back for, say, 5:45? Thanks, everybody.